My name is Mahmoudul Hassan, and this is my student ID. My student ID is 20064687. And today I'm here as an advisor to represent my client, Ethicurb, in arbitrary proceeding against Spain by describing breach of Spain-Albania way. Ethicurb is an Albanian company that deals in electric telecommunication in 2019, and Ethicurb was appointed by Spain to develop a new project that will enhance the current telecommunication system of Spain. After entering into a contract with the government, Ethicurb started doing work. However, Ethicurb caused huge damage to the telecommunication system in Spain, due to which the government of Spain terminated the contract as they had to bear immense losses. In this regard, the discussion is directed towards the evaluation of legal issues and analyzes the conclusion from the client's point of view. Um, a contract between two parties involves a predefined purposes and standard agreed upon terms for a specific consideration. Those a failure to meet standard terms could be an issue for contract terminate and Tolhurst and Meek 2010. In the given case scenario, the government of Spain terminated the contract with Ethicurb as the cause of damage and non-compliance with the standard agreed to terms of the telecommunication system of management. In relation to this legal case, analysis has been conducted in the presentation and with the preparation with the help of Iraq framework to present arguments as the counsel or lawyer of the company. In addition to this, breaches between Spain and Albania government are also presented in this presentation. The issue is between an Albanian company, it's a group that is specialized in electric telecommunication, and the Kingdom of Spain. The company was appointed by Spain in the year 2019 to develop existing infrastructure, to which is entered into a contract with agency of the government and started to work. In the year 2021, serious damage by the company was discovered that had caused disruption of telecommunication service to millions of people. The financial loss and mismanagement caused the company to deliver the standards agreed to and the government of Spain terminated the contract despite and the attempts of renegotiations. The company refused to leave the project and continued to work on it, which caused protest in the country, and government deported the official of its curb and appointed its own official on the projects. In this given level case, the bilateral investment treaty agreement between the Kingdom of Spain and Albania is applied. The covered number of articles in the context of investment protection. In the long term and big contract, the loss of the parties' interest is essential to protected under the investment treaty from the stakeholders protection perspective in support of the Article 3 of Albania. Spain with 2003 has also emphasized equitable treatment with the investors in the country of territorial security and protection of an investor and a stakeholder of company thereof. Discriminatory actions are prevented by government and management of a company. Discriminatory actions are prevented by the government and management of the system of the interest protections of the parties. As per the rule, it is essential to consider every aspect of the case, including residents, investor, and stakeholders. As per Article 5, treaty under any condition the investment made by company in another country shall not be expropriated and nationalized. In addition to this, the state should not take any measures that results in expropriation and nationalization. However, if there is a need to do so, there should be a reasonable compensation provided to the company. The value of expropriation should be equivalent to the market value of the investment expropriated. There is also a provision of interest as per commercial rates on the value of investment. In addition to this, the investors have to ask for a review from a judicial authority to consideration the valuation process and compensation provided a party. The condition in which a party faces loss due to the armed conflicts, revelation, national emergency, and civil disturbance, then the party should be provided with reasonable compensation. Article 6 of the treaty suggested that it is necessary to provide a reasonable compensation to a party facing loss due to the agitation and the insurrection. In this concern, it is evaluated that it is a responsibility of the government to provide protection to the public and the investors. The condition in which the government is failed to perform the action, then it has provided compensation to the party facing the loss. Distraction to investment by the authorities and force this that is not necessary as per the situation is not justifiable, and the investor should be provided with reasonable compensation for the loss. In the context of the dispute settlement, Article 10 of Albania, Spain with 2003 has focused on and emphasized diplomatic channel usage application from negotiation date. If dispute settlement is not possible within 6 months, arbitral tribunal party involvement is considered at the party's request. Each party shall perform arbitral appointments within the arbitral tribunal set up, then select a chairperson from a third country by the chosen arbitrators. Generally accepted principles of international law or predefined principles are taken as the base of decisions by arbitration within the dispute settlement. Thus, the arbitral tribunal plays a considerable role in setting such as contract dispute and settlement process. Without due consideration to the renegotiation, the contract termination is followed within general Spanish law and rules. Under the law of Spain, long-term contract renegotiation is not regularized under any specific legislative provision. Contract termination is a consideration valid before the maturity or end date of a contract under Section 3.1, which is applicable in the given case of Spain and Albania with. As per section, the counter party performance based on reasonable factors or basis is not satisfactory, and the agreement can be dismissed. Then Article 11 of the treaty suggested that in the condition of a dispute between the parties of the investors should try to settle the disputes through negotiation, and if it is persist for more than 6 months, the investors have the right to go to the competent court in the territory in which the parties has made the investment. In addition to this, the parties also have a right to go international center to settlement of investment dispute. Established under the Convention of Settlement of Investment Dispute between state and nationals of the states. To resolve the dispute, the parties can resolve the dispute with the arbitration, conciliation, and fact-finding proceeding. The provisions are made to resolve the dispute and provide justice to the party that is facing issues in the investment in other countries. In the case, the investment of article are exaggerated by government of Spain by the official of Spain that are equivalent to the nationalization of the company. In this condition, as per Article 5 of the treaty, the effort equivalent to appropriation should be provided with reasonable compensation by the government. The company had invested a heavy sum of amount in the project, and the nationalization of the company by changing its management will cause heavy loss, due to which it should be provided with reasonable compensation. As per Article 5, Ethicurb should also ask for review from a judicial authority in order to consider the proper valuation of the investment and provide to sum to the company as it faced a huge loss in the market. According to Article 11 of BIT, the condition in which the parties are unable to settle the disputes after 6 months of conflict and the attempts of negotiation fails, then the parties may approach ICSID in order to ask a suitable method of resolving the dispute. In the concern, Ethicurb should also approach ICSID and ask for a proper method for dispute resolution such as arbitration, fact-finding proceeding, and conciliation. As both of the countries, Albania and Spain, are member of ICSID, the party can approach it and ask for a suitable method to dispute resolution. In the dispute resolution, the company should ask for compensation in alignment with Article 5 as per company faced heavy loss in the market due to the nationalization. In reference in involved defined rule law applicable in the case, it has been analyzed that a contract between Ethicurb Albania and the Spanish government has been breached in a relation in the protection of a party investor's interest in the region on the ground of the performance terminated of the contract, irrespective of the protection and security aspect of the investor and associated stakeholders have been taken in the case. For instance, in the case of Siemens versus Argentina, in reference to the protection norm of the bid, it has also been generalized the both parties agreement to the decision of the termination has also been ignored in the case, which is essential to be valued as the prime requested in the arbitration decision. Termination of the contract was not accepted by Ethicurb because of the huge fund investment, and thus the lack of agreed decision related to the termination has also indicate a breach of contract in relation to the final termination and settlement. Thus, it has been generalized that all parties' interests are secured that, and thus the arbitral tribunal setup should be indispensably valued and considered. As per Section 10 of the BID, arbitration is the best possible measures that to be forced focus on the case, which can be highlighted as a breach. In case of on dispute settlement or negotiation with defined 6 months period, the arbitration appointment by both parties is prime consideration in the tribunal setup, and further process such as counselor's appointment the proceeding in favor of the parties interest without any arbitration process. The decision by party that is not agreed upon by another party involved in the investment has been indicated as a breach of the contract in a relation to the lack of conformity with the standard procedure. However, in relation to the renegotiation clauses in the BID, no such breach can be considered in the termination of long-term contract. On this basis of the discussion, it is concluded that the deportation of the official by the government of Spain in appointing the team of own personnel are not suitable for the treaty and should be considered as expropriation of which the company is liable to get proper compensation. The investment of the company is wasted and also suffers from reputation loss, due to the which is liable to for compensation. In addition to this, the company also tried to negotiation several times, and there was no such appreciation from the side of Spain to acknowledge it and take necessary steps to resolve and dispute, which shows a lack of interest from the government in resolve the conflict. As the government is negotiating, the company has only one way to requesting arbitration, as it on only suitable method available for the company to get reasonable compensation as per provision of the treaty. The company should go to ICSID and ask for a method for resolving the dispute resolution. There are available methods for dispute resolution such as fact-finding proceeding and arbitration and conciliation, to which the company should choose one and ask for the reasonable compensation is facing huge loss due to the step taken by the government. In the context of given case assessment, the balance is obligation between the parties, such as the Kingdom of Party and Spain, is one major argument in the case. As per the general rules, contract termination can be feasible in case of the non-performance, but full protection of the investment cannot be ignored. That is a major element of bid. Ethicurb has also made huge fund investment in the contract, and those solvency and stability of this company from the perspective of social and economic development cannot be ignored. The mutual decision of the dispute or negotiation can be taken through an arbitration process that was not valued by the Spanish government. It can be concluded based of analysis analyzed on applicable that law that there have been have breached between the Kingdom of Spain and Republic of Albania in context of Article 3 and 10 emphasize the investor security, the protection, and tribunal involvement. The contract termination and further decision of the senior management team of Ethicurb deported decision or appointed of its own personnel are not in compliance with Article 3. The Kingdom of Spain disciplinary measures and lack no concern of the personal and stakeholder security and protection are indicated a breach of the laws define investment protection. Basis on Article 10, the lack of arbitrary involvement in the contract termination can be marked as a breach of the bid between Spain and Albania. It has been generalized that an arbitral tribunal is a setup for the dispute settlement in the primary requirement of to a fair decision. That's all. Thank you.